Supreme Court of Canada offers important thoughts on the feminization of poverty. I'm Russell Alexander. The Supreme Court of Canada issued an important family law ruling recently. The case deals mainly with the law around claims for historical child support, meaning support sought at a time when the child has matured beyond the eligibility threshold. Legally, it's a hefty decision, and with the topic of at least one or more upcoming blogs that we have, we will cover some of the substantive elements of this case. But for now, we will introduce this landmark judgment by highlighting some noteworthy observations about the policies and principles behind child support generally, offered in particular by two of the Supreme Court justices. All 9 members of the Supreme Court panel presided over the hearing and agreed on the outcome, which turned on the proper interpretation of various legislation and case law dealing with child support. However, some of the justices preferred to issue separate but concurring reasons. In particular, Chief Justice Wagner and Justice Martin offered some profound and comprehensive observations on the nature and legal right to child support. Whether current, retroactive, or historical, these esteemed justices wrote the following. The purpose and the promise of child support is to protect the financial entitlements due to children by their parents. Canadian jurisprudence has not consistently fulfilled that promise when it comes to historical child support, which is the term used to describe when retroactive child support is sought after the child no longer qualifies as a beneficiary under the applicable legislation. This is evidenced by the contrary judgments across different provinces about whether applications for historical awards can be considered, and a growing body of jurisprudence and social science findings demonstrating that sometimes parents delay their application for child support to protect their children from the harm or because making an application is impractical or inaccessible in their circumstances. Child support obligations arise when a child's birth or the separation of the parents. Retroactive awards are recognized way to enforce such pre-existing freestanding obligations to recover money owed but yet unpaid, such as debt that is continuing obligation which does not evaporate or fade into history upon the child's 18th or 19th birthday or the university graduation. In short, allowing a recipient parent to make claims for historical child support is in the best interest of children and promotes equality and access to justice for all. Child support issues rarely make their way to this court due to the high cost of appeals and the comparatively low value of the awards. The evasiveness of review attaching to historical child support issues justifies that the court begins to discuss and reconcile deeply divided and confused jurisprudence, which prevents the hearing of historical child support claims across Canada. After a detailed review of the legislative and historical foundations of child support principles in Canada, the justices went on to consider some of the important policy considerations and commented on what they called the feminization of poverty. 1. Access to justice, whether seen as a statutory authority, referred to as jurisdiction, or redefined as standing. The procedural bar that originated in prior case law prevents access to the justice system for Canada's children. The courtroom door should not be closed because certain categories of debts owed to children are classified as coming too late. As they discussed later in this decision, keeping with the whole types of claims from the court creates hardship for children by caregivers by contributing to the underfunding of children and the feminization of poverty, the court wrote. Arriving at a modern understanding of child support is the right of the child, enforceable by court order, or has taken a great deal of time and is the result of hundreds of years of progress and numerous shifts in thinking about children, human relationships, societal roles, and the legal responsibilities. The status of children has changed dramatically from the time when children were viewed as property and the payment of monies for their upkeep was grounded in more grace and generosity than legal duty. Today, children are viewed as individuals who, as full right bearers and members of a group made vulnerable by dependency, age, need, merit, requires society's full protection. This includes a call to the real resources of their parents, translated into a right to child support based on the parents' actual incomes. The court also looked at the relationship between child support and poverty. In 1994, the Supreme Court took judicial notice of the significant level of poverty amongst children in single-parent families and the failure of courts to contemplate hidden costs in their calculation of child support awards. 3 decades later, it remains true that gender roles, divorce, separation, and lone parenthood contribute to child poverty and place a disproportionate burden on women. A bar against applications for historical child support means children have gone without their due, and the law provides no remedy for the hardship that has created for children and their caregivers, most of who are still women. Women in relationships are more likely to suffer intimate partner violence than their male counterparts. As a result, they are more likely to leave their home and belongings and their financial security behind to seek shelter or become homeless. Given these circumstances, women will also face financial, occupational, temporal, and emotional disadvantages. Moreover, access to justice in family law is not always possible due to the high costs of litigation. In this larger social context, women who obtain custody are often badly placed to evaluate their co-parent's financial situation and to take action against it. Measures that place further barriers on the ability to claim and enforce their rights, like jurisdictional bar, inhibit their ability to improve their circumstances and those of their children. In historical child support claims, what is really at stake is money that ought to have been paid for the care and support of children, but were directed elsewhere. This means children and their caregivers do without, and this has a lasting consequence for each of them. As child support in this case poignantly said, as a child, I was confident, bright, and enthusiastic, ambitious kid. I'm a bright, ambitious adult. Somewhere along the line, confidence and enthusiasm fell to the wayside. Family law's holistic approach demands that we take into account interconnected nature of issues of child support, child poverty, and the consequent feminization of poverty. Given the gender dynamics in child support, legal rules cannot ignore the realities that shape women's lives and opens them up to experiences and risks less likely to be taken by experienced men, like intimate partner violence, a higher proportion of unpaid domestic work, accompanied by less work experience and lower wages. The burden of most child care obligations. As mentioned above, this landmark Supreme Court of Canada decision has many facets, and will form the basis of future blogs and videos that we're going to share with you. We hope you liked today's video. You can share it and subscribe. You can comment in the comment box below. We're going to endeavor to answer everybody's comments at the end of each week. Until next time, stay safe.